Okay, thanks for joining me for another video. I'm going to move on from 13.3, move on to 13.4. This is the bit that contains new content on policies and exceptions for separate and single-sex services. So I might jump around a little bit here. But before I do that, actually, I have one more point to resolve from here on 13.3.19. No, I don't. I thought I did. Paragraph 3.4.8, yeah, it's a crossover. So 13.4.8 states that the provider may consider that admitting an individual. Okay, let's go and find it. 13.4.8. Here it is. It may be that offering an alternative arrangement is not reasonably possible for the service provider or person providing a service in exercise of public functions, or that doing so would undermine the service being provided. This may be because of a particular type of service being provided, the needs of the service users, the physical constraints of the building, or because of the disproportionate financial costs associated with making an arrangement. The service provider may take account of the fact that if it admits the individual, it may cease to be a separate or single-sex service. I mean, really, what's going on in here is that they're basically providing for them to say they get no service. And this is actually a position that I've heard reflected by one of the commissioners of the EHRC. You can hear that they've been doing various different interviews, Baroness Kishwath-Faulkner and the other commissioner at the EHRC. You can hear them talking on the matter of exclusion and the willingness that they have to just remove all services from trans people, whilst at the same time making it appear that they're not doing that. Yeah, here it's basically it's saying, if the service would be, financially problematic for you, the cost associated with making that arrangement. So let's say you'd have to make 2 more bathrooms or 3 more bathrooms or rework your bathrooms, then you don't have to do that because the cost would be too prohibitive. Or maybe you've got a listed building or maybe something else. Then there's plenty of other situations in which maybe you're just not going to do that anymore. So this is a contradiction, really, with paragraph 3.319. So the single-sex services read in 13.319 says that paragraph, well, it strongly implies that the inclusion is very likely to amount to an unlawful sex discrimination. That makes any exception or different approach, such as the one suggested in 13.42, that's this one here, the different approaches in this policy, it makes them essentially null and void. You can't make an exception or a different approach. That's not, it's seemingly legally impossible because it'd be too perilous for the employer, for the provider, if they include trans people. So, yeah. So the code must clarify how the flexibility and exceptions suggested in paragraphs 14.42 and 14.44 can ever be lawfully applied to include a trans person in a single-sex service aligning with their gender identity. If paragraphs 13.319 simultaneously state that the inclusion renders the service no longer single-sex and very unlawful, I mean, the same thing's true of their inclusion for the athletics events earlier on and any other events where they say, oh, the inclusion needs to, if you're going to exclude, it needs to be a proportionate means of achieving a legitimate aim. However, these are all explicitly then go back and make that inapplicable. It's prohibited elsewhere. So these fundamental contradictions make the guidance and exceptions very unclear, really. Essentially, that's what it comes down to. That's the best case. The worst case is that they seem to prohibit almost everything related to trans people. Is the allowing of people of the opposite sex, for which trans women, the code defines opposite biological sex. It might be permissible and adds necessary flexibility without undermining the aim of the service. That's really vague. Like, what does that mean? The code has to provide clear, objective criteria for what undermining the aim of the service in the context of including transgender person is. So, for example, if the aim is women's safety, like, how does the inclusion of trans woman who is perceived as and lives as a woman automatically undermines this? There has to be an actual evidence-based risk assessment associated with this. So yeah. Anyway, I'm going to move on to the next point now, 13.44. So in this one, potential service user who wishes to access single-sex service for the opposite biological sex, the service provider, including the person providing the service provider, should consider whether it can accommodate the needs of the service user in a way that achieves a fair balance without compromising the single-sex nature of the service. Like, this needs to be reframed because the paragraph discusses accommodating the potential service user. But it misrepresents trans women seeking to access service as seeking to access opposite biological sex service to her lived reality. Really, it should be reframed to address a scenario from the perspective of a transgender person seeking to access a service that aligns with their gender identity, and that would clearly provide a more respectful guidance than the current phrasing, which includes biological sex, in a way that immediately frames the trans person as an outsider to the service that they identify with. Yeah. It also assumes that one has to not do what it says is compromising the single sex nature of the service, but it doesn't compare that to any other safety considerations, and that's it just assumes. So okay, 13.45 suggesting offering a separate service to individuals and others in similar circumstances could be interpreted as advocating for segregated facilities for trans people. I mean, that's essentially what they're advocating for. The code must clarify that offering additional separate services must not become a default for segregating trans people or as a pretext for excluding them from appropriate mainstream single-sex services that align with their gender identity, where inclusion is possible and safe. You know, it's not always possible that there's enough trans people to run a service. You know, a children's centre that run a mother and child group, father and child group. Are they going to now run a trans mother and group and a trans father group, or is they're going to have to run a generic parent group? But then, if generic parents, if trans people, if cisgender people are entitled to share their experiences with other mothers or other fathers, people who share their gender identity, you know, why would trans people not be allowed to do that? Yeah. Okay. So yeah, that needs to talk about not segregating people. Let's have a look. What else do we have? 13.47 suggests adapting services such as offering toilets and individual lockable rooms to be used by both sexes. Yeah, as a less intrusive measure. And that is a welcome measure. You know, the code should more strongly emphasize the provision of gender neutral single stall services as the primary and proactive method for ensuring privacy and access for all, including trans, non-binary people, intersex people, cisgender people, everybody. It's the way that, it's the key way, the primary way that services can meet their PSED and HRA obligations. That's this should be framed as foundational solution, not like a reactive adaptation. This should be something fundamental that we are saying to people that they have to do before implementing these. And if we're using individual lockable rooms, it should be expressly stated that these are in addition to the radar key locked facilities, you know. Yeah. It's going to leave, because that's going to leave disabled people with no facilities. Let's have a look. The section discusses exceptions largely through the lens of sex. It lacks clarity on how decisions about exceptions must comply with the duty to avoid gender reassignment discrimination. So, where are the issues that butt up against this, and how is it discerning between them? The explanation of legal rights and responsibilities must integrate how the duty to avoid discrimination because of the gender reassignment applies when considering exceptions or alternative arrangements for trans people. If an exception is denied or an alternative offered is inadequate or demeaning, how are the trans person's rights under the gender reassignment characteristic protected? Because that is unclear. There's no mechanism for that. So, okay, right. So that's it for my on this section. I'm going to move on to question 48 and change 13.5. Let's have a look. So with this change, we are looking explicitly at the updated section on separate or single-sex services in relation to gender reassignment. So we've got 15. Here we go. So the first point that I'm going to stop at is 15.53. So if a service provider, including person providing a service in the exercise of public functions, decides to have a separate or single-sex service that allows trans people to use the service intended for the opposite biological sex, the service will no longer be separate or single-sex under the Equality Act, is also likely to amount to unlawful discrimination. I think that probably this point is adequately covered elsewhere, but for the same reasons, this paragraph is mirroring problematic 16.319 and must be removed or fundamentally rewritten. The assertion is that including trans people in single-sex services aligned with their gender identity is very likely or just automatically unlawful, and that lacks robust legal justification, so they need to justify that clearly here. I don't think they'll be able to do that because, like I said, there isn't any case law on that. They're just kind of making it up. It makes any subsequent discussion of exclusion of trans people, so from services related to their biological sex, seem predetermined. You know, there can be no issues of proportionality when things are done so absolutely like this. So why does the code frame trans-inclusive women's services that exclude men as very likely unlawful sex discrimination without allowing for the same ability of excluding men as a proportionate means of achieving a legitimate aim, excluding cisgender men? You know, it's asymmetrical application of the duty. Okay. If it is justified to provide a separate or single-sex service, then it will not be unlawful discrimination because of gender reassignment to prevent or limit or modify trans people's access to that service for their biological sex, as long as doing so is a proportionate means of achieving legitimate aims. So they're saying that you can. So it's articulated in the example below. For example, a trans man might be excluded from women-only service if the service provider says that because he presents like a man. Other service users could reasonably object to his presence, and it's a proportionate means of achieving a legitimate aim to exclude him. So this is talking about excluding trans men and women from all facilities associated with them, all gendered facilities associated with them. And that really should provide stringent, objective criteria and very high thresholds for what constitutes a proportionate means of achieving a legitimate aim, when this involves excluding trans people from a service designated for their supposed biological sex due to their gender identity presentation. That legitimate aim cannot be based on transphobic prejudice or vague notions of alarm or distress, because that can be anything. That could be absolutely anything. In this sentence, they are allowing for any gender non-conforming person to be removed from any facility on the basis of the fact that somebody might reasonably object to their presence. That is absolutely disgraceful. Yeah. So, yeah, what really needs to happen is that there needs to be really strict criteria provided for when this can be the case. Okay. not vague notions of alarm or distress. That's what 13.56 talks about, alarm and distress. You know, and when you can be excluded. A legitimate aims for excluding a trans person from a single-sex service for their biological sex, maybe to prevent alarm or distress from other service users, whether it's reasonable to think that their presence in that service as a trans person will cause the alarm or distress. So they don't even have to cause alarm or distress. You might go, well, I might reasonably expect that others could be alarmed or distressed by you. That means that is an incredibly low bar. Yeah. And if it's being considered on a case-by-case basis, it needs to be made clear how this is going to avoid people being targeted for discrimination based on their perceived identity, you know. Yeah, it should consider whether there is alternative services for the person to use. Yeah. In such cases, it is very unlikely to be proportionate to put a trans person in a position where there is no service that they can use. How? Yeah, that is, okay. Firstly, that's contrary to what some of the other people are saying online. People like I think his name is James Moran, who published several articles also for well-respected journals advising people that they are able to advising organizations that they're able to just blanket ban trans people from all of their facilities, and you know that would be legitimate so long as you know it would be financially prohibitive for them to accommodate them. Also suggesting that they clear out the facilities and put a sign outside, so and then while the trans person uses the facilities, and then they can clear everybody out. I mean, these things are absolutely hideous pieces of advice. I don't know how they comport with the obligations under the Human Rights Act. In fact, I'm pretty sure that they wouldn't. But anywho's, let's not get mired in other legislation. 13.58. The service provider does not act proportionately. Okay, yeah. Now, there are some conflicts. Here we go. Let's go. I'm going to skip forward to this example here. A trans man attends a gym frequently and uses the women's change room consistent with his biological sex. If the gym owner decides that he can no longer use the women's change room and there is no other change room he can use, this may be a disproportionate decision. If it's disproportionate, the gym owner will not be able to rely on the exception for gender reassignment discrimination from Section 3, paragraph 28. The trans man will be able to bring a complaint of gender reassignment discrimination because he has been treated less favorably than a woman who does not have the protected characteristic of gender reassignment. Yeah, well, it's currently very unclear, and its internal logic appears flawed given that the code's definition of a trans man's sex as female for the EA 2010 purposes. It needs to clearly state why the gym owner would decide that the trans man can no longer use the women's changing facilities if he's, according to the code, is using it consistent with his biological sex. Is it due to his male presentation, causing them as per 13.56? This must be explicit. Yeah, that should be said. If it's for his sex, for the act is female, how is he being treated as less favorably than a woman who does not have the protected characteristic of gender reassignment? If both initially are allowed to use the women's change room, the comparator and the less favorable treatment need to be clearly explained. Right? This might seem it's a point in discrimination law, right? So then it's a clarification of the comparator. The example should be rewritten to clearly illustrate a scenario where a trans person is excluded from a service for their biological sex due to their gender reassignment, e.g. male presentation, and then clearly explain how the test of proportionality from section 328 would apply to determine if this is a lawful gender reassignment discrimination or a justified exception. Like, it should be making very clear what the differences are between those, because I mean it really isn't. Yeah, so there you go. 13.57. I'll skip back here for a second. The service provider should consider whether it was an alternative for the case to use. Yeah. The statement 18.57 that is unlikely for proportionate means to put a trans person in a position where there is no service that they're allowed to use is too weak, right? I mean, I'm glad that there's something in there that says something like that. I mean, really, it shouldn't be necessary, but still, the statement that's there is too weak. For essential services like toilets, basic changing facilities, the code must make it clear that the failure to provide these services and usable options is discrimination and a breach of the duty of care. It's not enough to exclude a whole section of society and just go, well, this could be, it's very unlikely to be. They shouldn't be put in like that. There's much stronger and clear language that should be used to explicitly ensure that adequate gender neutral single store facilities are provided before any change in policy that's going to change the designation. Crucially, the consideration of suitable alternatives has to address the widespread use of radar key, which is a point that I've touched on previously, so I'm not going to cover that. Yeah, but there you go. I'm not going to cover that in any more detail here. The impact of GRCs, again, it would be useful here for a statement on what effect the GRC has, and if it's none, it should be explicit all the way through. It should be clear if there are any, because these aren't the only pieces of legislation that are being described here. It's very easy to say, well, under the Equality Act, the ruling was that it meant this. However, the Equality Act isn't the only piece of legislation at play here. There are many pieces of legislation at play, and information that's collected, for example, that's part of this, that's collected and used for the Equality Act is also used for other to inform other pieces of legislation as well that weren't ruled on. So that needs to be made clear in each and every section. Ensure consistency with human rights principles. Really, an explanation on legal rights and responsibilities must be explicitly linked to providers' duties under the Human Rights Act 1998, the HRA, you'll hear me call that too. Ensuring that any exclusion under the Equality Act 2010 does not disproportionately infringe on trans persons' dignity, particularly Articles 3 and 8, and the right to non-discrimination in Article 14. So so that should be done, and also it should be made explicit that any changes in policies should be developed. Any organisation that changes its policies should develop clear and practical guidance using consultation and should be informed by relevant trans, intersex, and gender non-conforming groups to ensure that they've adequately captured risk and issues with application, because these aren't the kind of things that people who aren't familiar with these areas can capture. So let's move on. I'm going to move on to 13.5.8. Let's have a look at this one. In this, if the service provider does not act proportionately, this is very likely to amount to direct discrimination, direct or indirect discrimination because of gender reassignment. Yeah, there we go. 13.5.8. Nope, I think I've done with that one now. Okay, cool. I think I've already covered that one. Here we go. So we're going to move on now to question 51 and change 13.6. Change 13.6, clarify the is the updated content on communal accommodation. So in this, the Act does not prohibit sex discrimination, gender reassignment discrimination, where a person does anything in relation to admitting persons to communal accommodation or providing any benefit, facility, or service linked to the accommodation This exception applies if the criteria set out in paragraphs 13.64 and 13.66 are satisfied. Okay. We'll come to those. 13.62. So communal accommodations, residential accommodation includes dormitories, things like that. It can include things like shared sleeping accommodation for men and women, ordinary sleeping accommodation, residential accommodation, all a part of which should only be used by persons of the same sex, or because of the nature of the sanitary facilities serving the accommodation and such. So in this, here we go. Let's have a look. Find my notes. 13.6. So in 13.6.2, as this slide just here, the definition of communal accommodation relies on it being for persons of the same sex. Given the code that defines sex as biological sex at birth, this implies that communal accommodations must be strictly segregated by this definition, and the code must explicitly state that its interpretations of persons of the same sex in 13.62 means persons of the same biological sex at birth. It must then clearly articulate the direct consequence that under this code, that a trans woman defined as male cannot use women's communal accommodation, a trans man defined as female cannot use men's accommodation. This is a direct implication which underpins the rest of the section, but it's not spelled out explicitly with sufficient upfront clarity that this specific section on communal accommodation, and that creates a potential for misinterpretation. Yeah, so it doesn't say clearly what it means. It needs to be managed in a way that's fair as possible to both men and women inclusively. So how does it apply when the policy impacts? Moving here to 6.4. This exception only applies if the communal accommodation is managed in a way that is fair as possible for both women and men. How does it apply when the policy impacts trans people? Like the code must provide clear guidance and examples of what managed in a way that is fair so far as possible to women and men means in practice. It needs to clarify how that fairness extends to ensuring non-discrimination and safety for transgender individuals, intersex individuals who may be excluded from accommodations aligning with their gender identity. Does fairness necessitate providing genuinely equivalent safe alternatives for trans people? How does the provision of communal accommodation interact with people's lived realities? I mean, the provision of urinals to people who are post-operative or operative, I'm not quite sure the best way of phrasing that, but if you've had your genital configurations changed, it might not be suitable for you to use urinals, for example. And there's other examples of how fairness might not necessarily be might not necessarily be as simple as this example and this section assumes. So I think that really needs broadening out with many examples. Elaborate on the proportionate means of achieving a legitimate aim in 13.6.6. So excluding a person from a communal accommodation provided for their own biological sex. So this is getting rid of people from even their birth sex accommodation can be will only be lawful if it's a proportionate means of achieving a legit aim, and the matter which a service provider or person exercising public functions should consider are similar to those set out in paragraphs 13.21 and 2.2a. Like, this is a critical test for excluding a trans person from an accommodation designated for their biological sex. This is the last place that they would theoretically be able to sleep then. Yeah, they're already, if they're going away somewhere and they're there's 2 communal dorms and they're not allowed, the trans man is not allowed in with the men, and they're then disallowed from the women. They're placing them into quite a bind. And so this is a critical test. And it's more than quite a bind. It's a life-limiting decision. Yeah, the code has to provide specific, robust examples of what constitutes a proportionate means of achieving a legitimate aims. In this example, where a person is going to have their accommodation removed from them, what are considered to be legitimate aims here? Is it solely on the basis of the discomfort of the cisgender resident if they perceive a gender mismatch? Because this is going to exclude any gender non-conforming person. This is defined in a. This needs to be defined in a really narrow manner to prevent abuse. Very high threshold should be required to justify the exclusion of people, and it should also be noted how we disaggregate this from prejudice and against somebody for their gender identity. That's a protected characteristic. How do we could you give an example of when the exclusion of a trans person from both gendered facilities is a proportionate means of achieving a legitimate aim, and where it would be gender reassignment discrimination? That needs to be thoroughly exampled in each of these sections in each of the different ways. The code should clarify the safety and dignity of trans people, particularly those with reference to the Human Rights Act Articles 3 and 8, and how they're paramount to the considerations of proportionality, and how excluding somebody from their accommodation based on their biological sex because of their perceived gender presentation might how it might make people uncomfortable is unlikely to be proportionate, and also probably should make people aware of their personal obligations under the Human Rights Act. Okay, right. So it should also address the risk of double exclusion and homelessness, because the code implies that trans women is excluded from women's communal accommodation due to biological sex, and then excluded from the men's communal accommodation, which causes issues, and that leaves her with potentially no options. And the code has to urgently and explicitly address how that leading to a trans person or intersex person having no communal accommodation, like how that doesn't violate the provider's duty of care to provide a safe and dignified accommodation, you know. Yeah. So, and again, clarify the role of the gender recognition certificate in this context. It should provide actionable guidance. It should provide actionable guidance rather than vague references to considering alterations or further accommodation. The code needs to provide clear guidance on what's considered reasonable to expect in terms of altering existing accommodation or providing additional options like private rooms, gender-neutral sections within communal accommodation to meet the needs of trans people and avoid unlawful accommodation. So, because these are accommodations that people are going to have to start paying for to put in place. So, they need to be explicit and specific. How should the relative frequency of demand be assessed when without discriminating against smaller vulnerable groups? If you're going to be saying, well, I will run the group once a week for women, is that like once every 3 months for trans people? How does that factor into that should be covered as well? We are nearly at the end now, so I realise that I've been running. I'm slightly over for my half an hour segments here, but we are coming up to the last section. So I am going to move on to, where are we? Page updates. I think we're on to now. Actually, there are no further changes in this section. The last consideration would be the final section, which asks you. I'd have to click through to see it, but it asks you. It's question, I think it's 52. Question 52. Any other feedback? So these are the areas where I added in some other things. I have to say it must be stated unequivocally that the widespread implementation of this guidance, which would effectively compel many transgender people to use facilities incongruent with their lived gender and appearance en masse, it will foreseeably and inevitably lead to an increase in dangerous incidents in facilities. This will include confrontations, harassment, violence within bathrooms, change rooms, and other sex-segregated services. They are not abstract possibilities, but they are near certain predictable outcomes. the EHRC has to recognise that it's profound responsibility for the real-world consequences of issuing this guidance, and with such significant impacts. If foreseeable harms occur and as a direct result of this guidance, particularly if it's found to have been issued with adequate prior risk assessment, comprehensive equality and human rights impact analysis, so the EQRIA, including considerations of the PSED, or without due regard for existing statutory protections, the lived realities of those affected, questions regarding the Commission's own due diligence and accountability will be raised, because if there's real world damage from this and they're shown to have not performed that kind of due diligence, it's going to be an issue. The draft code of practice must make it absolutely clear to service providers neither the Supreme Court ruling nor the specific definition of sex within the Equality Act nor any guidance issued by the EHRC diminishes or negates any fundamental common law duty or duty of care to all service users that all service users have, nor does it absolve public authorities from their direct obligations under the Human Rights Act 1998, particular section 6. Service providers cannot simply cite the EHRC guidance as a blanket defence if their implementation of it leads to foreseeable harms, unlawful discriminations, or breaches of individuals' human rights. That's not going to be something that they can do, and the guidance should be very clear on that. And they retain their independent responsibility to ensure the safety, dignity, and lawful treatment of everyone, which necessitates conducting their own thorough local risk assessments, thorough EQIAs, HRA compatibility checks, and implementing appropriate mitigation measures. So, all of the organizations that are going to adopt changes need to have gone through each of these steps in a transparent risk assessment and appraisal stage, and also involve feedback from gender non-conforming, trans, intersex, and other relevant affected individuals before making any change to facility access. The overall impact on transgender and intersex people's rights, safety, and dignity. The fundamental direction of this draft code is profoundly concerning, and it codifies widespread discrimination, segregation, and exclusion for the transgender and intersex communities, and organizations like the Human Rights Watch have warned about. You can see articles from them. It's probably worth referencing them. The code's current form appears to prioritize rigid biological sex at birth definitions over the lived realities, safety, and dignity of trans and intersex individuals, creating more hostile and not equal environments. It hasn't really addressed at all the issues of what happens when people are confronted in bathrooms. That's a complete abdication of its duty. Also, the undermining of the Gender Recognition Act. Throughout the draft, the changes constantly implied that the statement of the gender recognition doesn't alter a person's legal sex for the purposes of the Act, and it effectively negates the for all purposes intent of the Gender Recognition Act. With many crucial areas of public life covered by the Equality Act, the code doesn't address the remaining utility and legal standing of the GRC, and although it might want to avoid that as an issue, it really needs to tease those issues apart. Because they're inherently mixed. The failure to reflect scientific and medical nuance. The code repeated reliance on simplistic biological sex and sex at birth or birth sex definitions that it uses and it doesn't acknowledge the physiological changes resulting from hormone therapy for transgender people, or the biological diversity of intersex individuals, and that's really problematic. It's using and reinforcing these erroneous terms, and that is problematic. And that this isn't just my opinion; it's an opinion that the British Medical Association have also shared. They described it. They described they described it as reductive, trans and intersex exclusionary, and biologically nonsensical. Yeah, so it should be grounded in science and understanding. There's insufficient safeguards. In fact, there's very little here to do with safeguards and safeguarding of gender nonconformity. Um, Many of the chapters, like chapter 13, 2, 3, 5, and 6, rely on terms like proportionate means of achieving a legitimate aim, necessary, reasonable, objection. These terms are scattered throughout, but none of them are adequately defined, and most of them are terms that people will be applying based on their prejudices rather than definitive evidence-based risk assessments. The code needs to set much higher threshold in this regard throughout. Examples like 13.311, 13.312 show inadequate prioritisation of gender-neutral facilities. To be honest, the UK government changed rules around the provision to limit the provision of gender-neutral facilities in buildings recently. So that's completely contrary to this code, and backwards and forwards nonsense that was done under the Tory government. But yeah, more needs to be done to prioritise these and think about transitional periods where where businesses have a chance to do things like, for example, change all of their facilities to single-stall unisex facilities. Let's have a look. There's generally a chilling effect on this, and actually, to be honest, there's a lot of inconsistencies. If I'm looking broadly over the top, there's a lot of things saying, well, things need to be done as a proportionate means to achieve a legitimate aim. But then in another section, it'll say that the inclusion of any trans person in any single-sex group is inherently discrimination against somebody. But yet then it will say that they can be included in other areas. And really what's happening is there's so many broad and vague exclusions in here that the whole thing serves to, I would argue intentionally, but at least in actuality serves to have a chilling effect on all trans inclusion. It doesn't focus on proactive prevention of harm at all, to be honest. It doesn't. It really needs to focus much more on that, and it really needs to demonstrate co-production. There is little throughout the process that demonstrates that that trans people have been involved at any stage of the process, and I think it's really high time that they start including that. I don't think, is there anything else that I haven't brought up? I think I've made points about the consistency with the gay marriage and differences in data. I think I've made those. I have to say, another thing that I probably should raise, I'm not sure whether I raised it before, was that I think we would be the only country, certainly the only country that I can find that's made rules of banning trans people from both their acquired gender and also their original birth gender. I've not been able to find any such broad and aggressive restrictions anywhere else in the world. Yeah, I think if you're trans and you're married in the UK, I think I'll go with that point. UK Supreme Court states that one of the reasons they made the judgment was that people are not attracted to a certificate. I think I've made this point earlier on, but for those, for X1, that certificate was not even your sex or birth; it was who you are, how you live. But yeah, now they seem to think that it's okay to say they're attracted to the certificate you had as a baby. That seems really immoral. Yeah, I think I've covered everything that that can reasonably cover here. I hope you found that useful. I know it's been long, but if you filled in the consultation, then thank you. Good luck. I'll probably do a video on writing to your MP at some point soon as well.